Thank you all for coming. This is my first trip to Lansing, and I've seen enough to hope that I get to come back a lot. I'd like to thank everybody who was responsible for the setting up of this symposium. That would, of course, include Professor Trudeau, who has been unfailingly competent and professional throughout. Justice Brennan, who pretty much literally wrote the seminal article on this subject. The Cooley Law Review, and perhaps most of all, those people who were responsible for setting up the tables, putting in the microphone, and getting the food and drink here. My area primarily, my area of research primarily, is the founding era. And so, as the moderator has just told you, I'm going to be setting the stage. I only have a half hour, and there's a lot of material to cover. So I'll speak a little bit faster than I normally like to, but if you have questions or concerns, we can raise those on Q&A. Don't try to get everything in your brain all at once. There has been a great deal of misinformation, and there are many questions out there about this convention process. And I'm going to put the process on reset a bit, or perhaps give you an instant replay, so we can look at the process the way the founders looked at it. One thing that I hope you will never hear from my lips, at least today, in discussing this particular type of convention, is the words, hopefully this is the last time, constitutional convention. Because a convention to propose amendments is not, properly speaking, a constitutional convention. I have made the mistake of calling it that often, but it is a critical mistake because it causes people to misunderstand what it is all about. The Constitution gives the convention a specific name, a convention to propose amendments. And I think we should call it that, or perhaps an Article V convention or amendments convention. Now, before I go into how the founders looked at this, I need to make two preliminary points. Preliminary point number one, the way Amendment 5 works is that it provides for amendments by empowering clusters of legislatures and conventions. It empowers legislatures, state legislatures, to apply for a convention to propose amendments. It empowers, under certain circumstances, state legislatures to ratify amendments. It also empowers conventions, and it gives some powers to Congress. The powers under Article V come by reason of grants from we the people in the Constitution to these various conventions and legislatures. Those power grants also bring with them certain subsidiary powers that we call incidental powers. And one reason it's important to understand founding era custom is that it was established doctrine at the time of the founding, and to a certain extent today, that these incidental powers are defined in part by custom. In other words, the kinds of things that a convention to propose amendments can do, the kinds of things that the applying states can do, are supposed to be the kinds of things that it was customary for them to do in 1787, 1788, and so forth. So we have to look at founding era customs to understand what it means to apply for a convention, or to call a convention, or to propose amendments, and so forth. Second point is to understand thoroughly why this state application process was set up. If you can take Article V, and I realize it's a formidable block of type, and dissect it, you will see that there are methods for proposing amendments, and there are methods for ratifying amendments. And the convention method is one of two ways of proposing amendments. The other way is for Congress to propose them. Why did the founders provide for two separate methods of proposing amendments? Well, they thought that Congress usually would do the proposing because Congress was involved with the government and knew how well things were working. But they provided for this other method that would come from the states. They provided for this, is there a speaker? Oh, okay. They provided for this other method that would come from the states because they recognized that sometimes there would be a big problem that Congress couldn't or wouldn't deal with. This has happened several times in our history, notably just before the Civil War. A lot of people wanted compromise to stave off war, and Congress was deadlocked and couldn't take the action that was necessary to stave off war. And so some people suggested a convention is the ideal mechanism to use, but it never got far enough. So it's a way of bypassing Congress. That's the purpose of the convention method. Okay, with those initial comments that the Constitution empowers conventions and legislatures and that this method is designed as a congressional bypass, let's look at what conventions were during the founding era. This morning I got an email. The email quoted a person who purported to be a constitutional expert who said, you know, the only federal convention that's ever been held was the one that met in Philadelphia in 1787, and we don't really have much to go on. That's the only precedent we've got. And I used to think that too, but it's not true. It's not true. In fact, the convention device was a favorite device of the founding generation. The original meaning of a convention is just a meeting. But by the time of the founding, the word had become identified with a particular type of meeting, a type of ad hoc assembly that was designed to deal with governmental problems, as opposed to a legislature that's not ad hoc and that sits all the time. The convention was to come together, was to meet, was to solve a problem, and was to go home. And so there were conventions in England in the 17th century, a convention that brought back Charles II after England's ill-fated experiment with republicanism. There was the convention that brought William and Mary to the throne in 1689. There were conventions in 17th century America. And there were a lot of conventions during the founding era. The founders had a great deal of experience with conventions. Conventions set up new state governments after the royal governors had been sent packing. Conventions ratified the Constitution. Conventions also dealt with problems among states, federal conventions. There was a Providence Convention, a convention that met in Providence in 1776 and 1777 that dealt with price stabilization issues. I'll read you a few more. You get an idea of how many of these things there were. There was a Springfield Convention of 1777. It dealt with currency and wartime profiteering. A convention in York, Pennsylvania, called by Congress in 1777 that dealt with prices. There was a convention in New Haven in 1778 that dealt with wartime economic regulation. There was another one in Hartford in 1779, and then a second Hartford Convention in 1780, the first one dealing with price stabilization and the second one dealing with the federal taxing power. There was a Philadelphia Convention, not in 1787, but in 1780, which dealt with issues of price stabilization. And of course, most famously, there was the Annapolis Convention of 1786, which was convened to deal with commercial issues. So there were a lot of these conventions. They had recognized prerogatives. They had recognized procedures. People understood how they met, how they worked in a way that we don't or that we don't typically understand today. Next point. You know, they say that there are two types of people in the world. There are those people who divide everything into two types of people, and then there's everybody else. And I'm going to take conventions and I'm going to divide them into categories. There were conventions that met exclusively within states, like the state ratifying conventions. And then there were others that met among sovereignties, either in the diplomatic field or among states. And of course, the state ones were called federal conventions. They followed somewhat different rules. The states that met within sovereignties represented the people directly. The people voted for their delegates. The delegates met to deal with the problem and then went home. The conventions that met among sovereignties, among states, were constituted somewhat differently. How they worked was that each state sent delegates to the convention, and they voted at the meeting by states. So the people are represented, but they're represented only indirectly. The second division I'm going to give you is that there were conventions that James Madison called, and Hamilton called, plenipotentiary conventions. That is, there were conventions that designed to deal with practically everything, write a new government, for example. But most of the conventions of the founding era were special purpose assemblies. They were designed to achieve a particular problem. They met, they dealt with the problem, or sometimes they couldn't deal with it, and they went home. What categories is a convention to propose amendments in? Is that a great popular convention? Is it a collection of all the people of the United States? Or is it a federal convention? Is it a plenary or plenipotentiary convention, as some people have suggested, that can do anything, overturn the government? Or is it a limited purpose convention? When you look at the founding era record, the answer is virtually without uncertainty. It's very clear. The Convention to Propose Amendments is a federal convention. It is a creature ultimately of the states, or more specifically of the state legislatures. And it is a limited purpose convention. It's not designed to set up an entirely new constitution or a new form of government. Well, how do we know that it's a federal convention? We know that it's a federal convention, at least you know if you looked at the founding era record, because first off, that's the only kind of interstate convention that the founders had ever known. And when they talked about conventions to propose amendments in the ratification process, they always talked about them as representing the states. And when Virginia and New York submitted the first applications ever for an amendments convention, in both of their applications, they referred to it as a convention of the states. And when Pennsylvania refused to follow Virginia and New York and said, we're not going to apply for a convention to propose amendments, Pennsylvania also referred to it as a convention of the states. So it's not a big homogenized national sort of thing where everybody gets to vote for one delegate from his or her own district. It is a collection of representatives of the states that shines through rather clearly in the founding era record. The people are represented, but they are represented indirectly. By the way, this understanding that the Convention to Propose Amendments is a collection of the states, this was continued to be widely understood throughout the 19th century. And in 1831, in a case called Smith versus Union Bank of Georgetown, the U.S. Supreme Court also referred to a convention to propose amendments as a convention of the states.